Mr. Cooper, we have jurisdictional and merits issues here. Maybe it'd be best if you could begin with the standing issue.
I'd be happy to, Mr. Chief Justice. Your Honor, the official proponents of Proposition 8, the initiative, have standing to defend that measure before this Court as representatives of the people and the State of California to defend the validity of the measure that they brought forward.
Have we ever granted standing to proponents of ballot initiatives?
No, Your Honor. The Court has not done that, but the Court has never had before it a clear expression from a unanimous State's high court.
Can you tell me that's a factual background with respect to their right to put the ballot initiative on the ballot? But how does it create an injury to them separate from that of every other taxpayer to have laws enforced?
Your Honor, the question before the Court I would submit is not the injury to the individual proponents. It's the injury to the State.
You might address why you think we should take and decide this case.
Yes, Your Honor, and that is the one thing on which I wholeheartedly agree with my friend, Mr. Olson. This case was is now properly before the Court, was properly granted, even if, Your Honor, one could defend the specific judgment below for the Ninth Circuit, a defense that I haven't heard offered to this Court. A judicial redefinition of marriage, even if it can be limited to California, is well worthy of this Court's attention, particularly, Your Honor, as it comes from a single district court judge in a single jurisdiction. I think
that begs, and Mr. Olson doesn't really focus on this. If the issue is letting the states experiment and letting the society have more time to figure out its direction, why is taking a case now the answer?
Because, Your Honor,
we let issues perk in, so we let racial segregation perk for 50 years. From 1898 to 1954.
Your Honor, it is hard to...
And now we're only talking about, at most, 4 years.
It is hard to imagine a case that would be better, or more thoroughly, I should say at least, briefed and argued to this Court.
It's too late. Too late for that now, isn't it? I mean, we granted cert. I mean, that's essentially asking, why did we grant cert? We should let it percolate for another... we've crossed that river, I think.
And in this particular case, to not grant certiorari is to essentially bless a judicial decision that that at least in the state of California, the people have no authority to step back, hit the pause button, and allow the experiments that are taking place in this country to further mature. That, in fact, at least in California, and it's impossible to limit this ruling, Your Honor, even to California. Even the Solicitor General's argument, he says, applies to at least 8 states. It's impossible to limit these propositions to any particular jurisdiction. So this Court would be making a very real decision with respect to same-sex marriage if it should simply decide to dismiss the writ as improvidently granted.